if you're trying to demonstrate what is in the best interest of the child, how do you prove that?
So the best interests of the child are determined by the statute itself. There's a specific statute that outlines, the enumerated factors for determining the best interest of the child. Anyone who practices family law with any level of experience and expertise is going to look directly at those statutes first, and dwell on them and apply an analysis of that, of each parent, through those provisions within that statute to determine what's in the best interest of the child. Again, some practical considerations, that people should be thinking about that people rarely do, are logistics. Think about your schedule today and marry it up against your child's schedule. If you were to do this all on your own, would it make sense? Would you be able to do that? That doesn't mean that you're necessarily excluded from your child's life because your job schedule doesn't necessarily support their schedule. But generally speaking, the court is going to make a logistical analysis in its determination. If you're consistently out of the home at 4:45 a.m. because that's what your job requires you to do, it's going to be very difficult for you to exercise overnight placement of your child, because how are they going to get to school the next day? Who's going to wake them up in the morning? And the child certainly isn't expected to wake up at 4:30 in the morning to be transported over to the other parent's house so that they can maybe fall asleep for 15 minutes before they get up in the morning. So beyond the statutory factors, I think you have to look at practical considerations like schedule, transportation, availability, and the like. What people often forget when they're married is that, you're doing this together. In some way, you're doing this together, and in the future, you're going to be doing this on your own. What adjustments can you make, not have you made, but can you make to support you doing this independently?
So you mentioned to evaluate the best interest of the child, there's going to be a list of factors that are going to be considered, one of which is any other factor that may be considered. But what are all the ones preceding that ambiguous term that basically means anything the judge is interested in?
Some of the more important ones are, first, the wishes of the child himself or herself, as communicated through the guardian ad litem. Something that's really important, and I think this is truly valuable for anyone that's going through this process, is the interaction and interrelationship of the child with his parent. Another one is the amount of quality time that the child has spent with that parent in the past. When courts are doing this analysis, determining the interrelationship of the child, they're looking at the closeness between the child and the parent, and these are often, by observation. If there's a family court study or a guardian ad litem appointed, those investigators are often going to want to see the parent interact with the child. And look, these are trained professionals. They know what they're looking for. They know when they can see an authentic reaction from a child, and they can see when it's coached, when a parent is coaxing that child to come over and it's forced. So it's pretty easy and it's pretty apparent. The amount of quality time that a parent has spent with that child includes the way in which that parent has involved themselves in their child's life. If a parent is simply a parent in name alone, they leave for work, they come back from work, they ignore the kids, go to bed and do the same the next day, there's a clear difference and a demonstrable difference between that and a parent who is waking the kids up, making them breakfast, getting involved in their school day. What projects do you have coming up? Taking them to the sporting events, coaching them, being part of their lives. That's all really, really important. Some other considerations are whether that child is going to have to adjust to a brand new life. If the child is comfortable where he or she is, and this is really important, and I say this to all parents when they're talking about, I think my child should do this or do that, and we talk about whether there's going to be a custody study and a guardian ad litem involved. I ask them very simply, let's say I were to talk to your child today. Let's say he or she were to be in front of me right now and you weren't here. Would I think that your child's pretty well adjusted? Oh, yeah, they say. Would I think that your child is intelligent and social? Oh my gosh, yes. Well, if that's the case, why are you proposing a change? If your child is well adjusted, if they're doing really well, if they're coming off as happy, as intelligent, do they have friends? Oh, they have plenty of friends. Well, then why would you change? And so the court's going to look to preserve the status quo if a child is doing really well, and a court is willing to disrupt a child's life if that child is not doing really well. So getting involved in that child's life, knowing what adjustments that child may have to make upon an action of divorce and a splitting of households, that matters. That really matters. What doesn't matter very much is that child's gender and that child's age. The courts really are not going to be interested in an argument from a mother that says, well, my daughter really needs me because she's a girl. Or a dad saying, my sons need me because they're now 14 and they're going to be young men really soon. The court will hear it, but the court's not going to give a great deal of weight to it. Instead, it's going to look at the need for regularly occurring periods of meaningful placement to provide predictability and stability. And that's actually the language of one of the provisions. They want stability, they want predictability, they want this for kids, no roller coasters.
You started to mention, or you slightly mentioned kind of how they go about validating that information. I believe you called it a court studies or custody studies. What are some of those mechanisms that the court's going to use to evaluate or prove the position of the GAL or prove the position of one of the attorneys?
The most important player is what's called family court services. Every county is going to be a little bit different just in terms of its resources within family court services. Larger counties that have denser populations and maybe a little bit more municipal money rolling through are going to have more robust family court services. For instance, Dane County has a number of family court service counselors and investigators, and they have a very kind of active office. Other counties that are a little bit more sparsely populated, the family court services office is maybe somewhere between 2 and 4 people. But either way, the primary player outside of the guardian ad litem is going to be family court services. And they're social workers. What they are is they're trained social workers. They know their craft. They're totally and completely dedicated to their craft. I'm often amazed at how committed these people are to what they do and the people they serve. It's pretty remarkable.
Thank you for watching this video. Please like, subscribe, and share. Your interaction with our content is greatly appreciated. Visit sterlinglawyers.com to learn more about our firm and meet our attorneys.